What happens if you fall out of love before the government falls in love with your paperwork? That question keeps immigration lawyers up at night, and honestly, it should keep you up too if you are mid-process. A spousal green card petition is basically a love story translated into government form language, filled out in triplicate. The government does not care about your wedding photos. It cares about Form I-130 and whether your marriage is still breathing when they finally get around to reading it. Here's the twist nobody warned you about. If the marriage legally ends, through divorce, before that petition gets approved, the whole thing usually just dies on the vine, like a houseplant nobody watered during a 2-year permitting delay. Think of it like ordering a pizza for a party. Then the party gets canceled halfway through the drive. The delivery guy, in this case United States Citizenship and Immigration Services, just turns around and takes the pizza back. This is because the entire petition, called the I-130, is built on one requirement: a bona fide marriage that currently exists. No marriage, no petition, no matter how many joint bank statements you filed as evidence. But here's where it gets interesting, and where a lot of people panic unnecessarily. If the divorce happens after approval, but before the actual green card interview or final decision, there are sometimes paths forward, especially if there was abuse involved. That is the VAWA self-petition process, which stands for the Violence Against Women Act, even though it protects men too, because Congress apparently loves an outdated acronym more than accuracy. Under VAW, if the marriage was legitimate but ended because of abuse, the immigrant spouse can sometimes self-petition and keep the whole process moving without the abusive spouse's cooperation. It is like the government finally saying, "Fine, we will let you keep driving even though the other person stole the car keys." Timing is everything here, and this is where lawyers earn every dollar of their consultation fee. A petition pending versus a petition already approved versus a conditional green card already issued are 3 completely different legal universes with 3 different survival strategies. If you already have a 2-year conditional green card and then divorce happens, you are not automatically doomed either. You can file a waiver, basically telling the government, "Hey, the marriage was real, here is proof. Please do not send me back like a defective online order." Proof usually means the boring stuff: joint leases, shared insurance, photos that are not just from the wedding day itself. Judges have literally said a shoebox of Applebee's receipts from date nights can matter more than a fancy album from one single afternoon. A lot of people assume any divorce equals automatic deportation, and that is simply not true. It depends heavily on stage and circumstances. This misunderstanding causes so much unnecessary fear that people sometimes stay in bad situations purely out of paperwork panic. Preparation really is the entire game here. Keep documentation running in real time, not scrambled together after a breakup. Rational thinking beats panic every single time, because immigration law rewards people who can prove a timeline, not people who just feel strongly about their own story. At the end of the day, this is less about romance and more about paperwork surviving heartbreak. The lesson is simple: love is unpredictable, but your documentation folder should not be. So if any of this is hitting close to home, or you just want to understand your specific situation better, do you want to learn more about our company? Check out our links in the description.